A physician assistant was fired by a Michigan hospital due to her religious beliefs, and now she's seeking to vindicate her constitutional rights and to protect other healthcare providers from a similar fate. Just this week, she received a favorable ruling from the U.S. Court of Appeals, Sixth Circuit, that will allow her lawsuit to proceed. It's kind of technical, but I'm glad we have here Kayla Toney. She's a lawyer with First Liberty Institute, and she's representing the physician assistant. Kayla, welcome to Washington Watch.
Thank you so much for having me.
Sure. So I try to stay out of all the legal minutia in Sixth Circuit, Fifth Circuit, but this is a really important case. Tell us about your client, Valerie, and what happened exactly, how she got into all this trouble.
Valerie is a wonderful Christian healthcare provider in West Michigan. She's actually the third generation in her family to work at her local clinic. And she worked there for 17 years. She had great relationships with her patients. Some of them were her second generation patients. They all really loved Valerie. And one day everything changed when the University of Michigan Health System took over her local clinic, and they started requiring training that involved LGBTQ plus topics. And at first it was just training, and then it became quizzes where she had to actually affirm statements that went against her faith, statements such as gender is fluid. And this really bothered Valerie because she's a person of deep religious faith. She has a very sensitive conscience, and she knew that she couldn't affirm these statements, and also that having to participate in gender transition treatments would actively harm patients that she deeply cared about. So all she did was she brought it up with her HR department. She asked for a religious accommodation so that she didn't have to check these boxes on the training about gender. And she was attacked. She was called into a meeting with hospital officials whom she had never met. They accused her of being evil and a liar.
Evil.
They told her yes. Wow. They told her she was going to contribute to suicide rates from patients with gender dysphoria. And all this when she had never even had a patient ask her for a referral for some sort of gender transition treatment. And she actually treated patients that were lesbian and gay, and she had good relationships with them. So it was truly a dispute about hypotheticals. But the harm was very real to Valerie because just 3 weeks after that hostile meeting, she was fired.
Wow, being called evil by an industry that sort of mutilates children and makes money off of it is kind of rich. And it always seems there's some Christian minding their own business, just trying to defile their conscience, who's always targeted in these cases. But, my research, I found that Valerie's not the only one. I know there was a teacher in Virginia who got a payout of over $500,000. She refused to use a student's preferred pronoun, and she got fired, and then she sued. And there's other cases like this, but they seem to be going different ways. So how our average viewer, listener here, are they really in danger of being fired from their job from misgendering someone? And what legal protections do they have, or is that the whole point of this case?
That is the whole point of this case. It would have been so much easier for Valerie to just move on with her life and try to forget this traumatic incident of her termination, but she did not want this to ever happen again. So that's why she sued in federal court. And so the legal protections that she is suing under and that folks should really all know about. First, there's Title VII, which is a federal law that protects all workers in the United States from discrimination based on religion, also race and age and national origin and other topics. But religion is protected in that statute. And so we claim in court that the hospital violated that law when they fired her because of her religious beliefs. And then also we sued under the free exercise clause of the First Amendment. And this clause protects the ability of religious people in the workplace to say, I don't believe in that. I'm not able to participate. Can you please accommodate me just like you accommodate a lot of other things? And so the argument in a medical setting is, well, there's always healthcare providers that might have a personal objection to, say, examining someone of the opposite sex, or maybe prescribing opioids or certain weight loss drugs, certain narcotics. And so if that's the situation, the schedulers can just place that patient with a different provider. And that actually happened all the time at Valerie's clinic. And so all she was asking for was just an accommodation so that, if a patient wanted to discuss gender transition treatments with her, she would just ask for them to be scheduled in advance with someone that was comfortable prescribing those treatments.
Right. And this is an important point I want to make. Sorry to interrupt you, but this is an important point to make because we saw the same thing with the Christian bakers and florists who were, sued for not baking. It's really need to be really clear that it's not that they are refusing to serve gay people or refusing to serve transgender people. Valerie was not saying, I'll just get this gay person out of my office or something ridiculous. The florist, the bakers, they would have made cakes and given flowers for any occasion, but they didn't want to make a cake for a gay wedding. And in the same case here, Valerie, she'll do any kind of treatment for a gay or trans person, trans identifying person, but it's the actual treatment. She doesn't want to refer someone for a gender transition surgery. Is that right?
That's right, exactly. And actually, a different court, the Eighth Circuit, just recognized that making a referral is actually part of the medical treatment process.
Of course.
So you're not just signing your name. You're saying, I, with my medical expertise, am recommending that this treatment is going to help. And from Valerie's faith and just from her medical judgment, she was concerned that these treatments might actually be harmful. And lo and behold, the Supreme Court agrees with Valerie, because just this summer in the ruling United States versus Skermeti, the court upheld some laws that states had passed to actually ban these types of treatments for minors because of the harms and because the medical science and research is just not there to show that transition treatments are actually helpful. And in fact, they often are harmful, and they often make some of the struggles even worse. And so Valerie, we feel, has been very vindicated in her concern as a medical professional by that decision from the U.S. Supreme Court this summer.
Right. Well, I think that's a great point you bring up. There's the conscience and religious aspect of this, of saying, I don't want to be a part of this. But then, as a medical provider, you can say, I'm not interested. I don't think this works. Kayla, thanks for explaining First Liberty Institute. Appreciate you coming on.
Of course. Thanks so much for having me.